How's it going? This is Sherrod with Oakhurst Legal Group, here with Pryde, Attorney Pryde, heading up Sherrod Sports Visas. How are you doing today?
I am good, Sherrod. How are you?
I'm awful. Horrendous.
Well, rightfully so, right?
That's right.
We are beginning to see a whole lot of denials coming through the pipeline.
That's true. That's true. Fortunately, our record is still as impeccable as anybody else in the nation, but we're hearing from, on our own end and also with a lot of attorneys around the nation that there's a lot of denials coming through and they aren't making sense.
Yes, sir. Yes, sir. And most of it, the adjudicating officers now just have some confidence in ignoring precedent. They set the rules, we obey the rules, we submit everything the way they want us to submit it, and they deny perfect cases.
Right. So you got to think about it. And clients will get frustrated about this, but we do hundreds of combat sports P1 petitions per year. The adjudicating officer might be looking at their first one. So out of all these approvals, it is very unlikely that we did something wrong because we do this every day, the same type of way.
Correct. And because we've been doing this a long time, especially for the O1 and the P1 visas, we have a down-packed model that worked and has worked for hundreds and hundreds of petitions that we have carefully tailored to meet the requirements of the USCIS. This is especially, true with the MMA petitions where the agent, is the petitioner, right? And we've appealed. We've appealed a case over the itinerary and won that.
That's right. So if you don't know, we primarily, although we do work direct with promotions, we are known for working with agents, gyms, and management companies to get visas for unsigned fighters. Now, last year, we did have a case that was denied where basically they said, this person's not in the UFC. How can you use the UFC itinerary to support their P1? And we successfully fought that, and we won that case using an I-290B appeal. And that's where you appeal it directly to USCIS. And this is rare because usually when they do that, they just kind of rubber stamp it, say like, hey, my boy made that decision. I don't want to overturn it. But we beat them over the head with stuff that makes sense, also known as their own rules. And we actually use this case in every MMA petition and every boxing petition that we submit on an agent basis. And it looks now, from time to time, they ignore it.
Well, it's a shame, but a new, hopefully, temporal matter for us to deal with.
Right. So with that being true, unfortunately, we're going to have to talk about what do you do in case of a denial. Now let Pryde kind of give the options.
Sure. We have basically three options. We've primarily really used two of them, and the third option is one of those that we're going to have to start getting into, correct? So when we got a denial, the first thing that we want to do is want to appeal that denial. And once we appeal the denial, we're going to also refile the petition. And then the third option that we have is just to litigate, is to sue them. We can sue the USCIS for their incompetence. And so the first two options, we usually will do them together. We appeal, and then at the same time, we file a new petition. And more often than not, almost all the cases that we've done that to, we've won the petition, or the second petition gets approved, even before the appeal is heard, correct?
That's true. That's true. So kind of let's talk about why we do it this way. So you definitely want to file the appeal, especially if you're in the United States, because that's going to help you maintain status. Because if you get denied, that means that they've cut your status while you're pending. So you're now in a legal status technically. It's not too bad as long as you don't overstay for 6 months. But when you timely file the appeal, that bridges the gap in time that you can go ahead and file that new petition. Because if
Correct.
you have the old petition gets denied, you can't just file a new petition right after it if you don't have a lawful status in between. So that's why we always file the denial, even though that they're not granted all that often. It's just so that you can maintain your status in the United States while we file the new petition. And to do
Correct.
that I-290B, it costs $675. And historically, you have 31 days to file the appeal. But right now, because of COVID, they're giving you an extra 60 days. So you get like 91 days to file the appeal. And that's why we do it at the same time. It's because a lot of times that new petition will get approved, but we do the appeal to keep you in status.
That is correct. And then that brings us to the final option, which is litigation.
Right. So litigation is a whole separate process from the appeal process. So you can litigate even if you haven't appealed. And with this one, we're going past USCIS, past the Board of Immigration Appeals, and directly to United States Federal Court. And we're just saying, and it can be a lot faster, because usually what happens is that these cases never go to trial because they don't want to set a precedent, which is something that they legally, by law, set by a judge, have to adhere to. So if you do go to litigation route, what we want to see is for the district attorney, for the, the lower, District of New York, or here it'll be the Western District of North Carolina, will call you up and say, hey, I don't know anything about immigration. I'm over here trying to deal with antitrust, corporate white collar crime.
Right.
What does this stuff even mean? And we say like, well, we filed a P1 petition, MMA. Here's a case we've already appealed and won, and for some reason your officers is ignoring that. They get on the phone with USCIS, say like, hey, do you really want this to go to trial? Because it looks like they've already talked to you about this. Can you just reopen it and approve it? And a lot of times that's what we've seen happens. Now, typically this litigation happens with H-1B. There's just not a lot of attorneys out there doing volume P1 visas. So there's not a lot of precedent out there, but we are going to be the precedent. We are going to push it, not only for our law firm, but for the other immigration attorneys out there that do sports-based immigration, to say, USCIS, we are not playing with you. Drop it like it's hot. Lawsuit, here it is.
With little to no choice, that is the option we are left with, right? And we're excited to lead the charge on federal litigation. We're not afraid to do that.
We're not afraid. We're looking at the chops. So USCIS, we'll see you in court.
We're coming for you.
Coming for you. All right, with that being said, sorry about the bad news, but we did give you some solutions to take with you. If you find yourself in a case of denial, remember, I-290B first to maintain status. Go ahead, file a new petition, and then level the playing field with federal litigation.
Absolutely.
So if you have any questions, don't hesitate to call the firm or shoot us an email. Have a great day.
Thank you.